Good morning, everyone. It's morning in the UK anyway. So hot on the heels of Ellen's explosive letter, basically accusing Lively of lying, and sticking because what happened here was Lively requested an extension of time. Oh, Wayfarer, they haven't done this and they haven't done that. Blah 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 blah. One of her usual letters. Wayfarer then slipped into the court and said, "Hold on a minute. These are the names of this is all the information she wants. You need to now deny this as moot," and the judge denied it as moot. Lively then craftily put in another letter, which she claimed was joint, right? Which would have then the judge almost always grants requests that are jointly made by the parties. So she claimed it was a joint request. The information in it was wrong as well. And I think that was deliberate, and I'm going to get to why when we go through this. And then she slipped in amongst a flurry of, motion of filings that were hitched in the docket all on the same day. It was like, here, take your card. Look at your card, and then put it back in this pack, and then hope that Wayfarer didn't find their card. That's basically what happened. But they did find the card, and then Ellen wrote a letter saying, "Your Honor, she's full of shit." We know nothing about this. They didn't even send a copy of the quote unquote joint request to Wayfarer, which is what you do. When you file something, you copy in the various counsel for parties involved, and they didn't. And Lively's team did not do that, which tells me that she was hoping it wouldn't be seen. She's now responding and going, no, Your Honor, it was just a mutual misunderstanding. I haven't read it in detail, so we're going to go and do that now. But we have the makings of a bitch fight, people. Just to let you know as well, my next video I'm going to be doing a bit later today is going to be the witness list. I'm going to go over that in some detail, I think. Okay. Dear Judge Lyman, Plaintiff Blake Lively respectfully submits this letter motion renewing her previous request for an extension of time for Miss Lively to exchange designations and objections with respect to the deposition testimony of Jennifer Abel and Steve Sauerers. Miss Lively first made this request on April 7th, and the court denied it as moot, along with other relief requested in the letter motion. Unfortunately, the request is not moot. Defendants' current position, as reflected in their letter of April 11th and correspondence with Miss Lively's counsel, is that their express agreement on April 8th to extend the deadline to file deposition designations was superseded by the court's order, which denied Miss Lively's earlier request for that same extension as moot. That is the sole basis on which defendants now maintain that Miss Lively reported a joint agreement to the court to which the defendants had not assented. Miss Lively's counsel was bewildered to learn, only after she filed the letter motion seeking an extension that she believed had been agreed to. Oh my God. of defendant's position. What it says, Lively is not happy. Right, here's the irony. Lively, who was hired as an actress, only an actress on a movie, then took over every damn role. And not only that, there's an interview of her admitting doing that, and she literally called it a rug pull, or likened it to drinking from a fire hose. Lively is now bewildered that someone has rug pulled her. In the hope of avoiding the need to raise this dispute again with the court, Miss Lively, oh, here we go then. Your Honor, if you don't grant this, I'm not going to shut up and go away. Miss Lively, in the hope of avoiding the need to raise this dispute again, Miss Lively asked defendants to honour their prior agreement and offered to serve her affirmative designations as to Mr. Sarris and Miss Abel by today, but defendants did not respond because it was a Sunday, right? This letter was filed on the 12th. That was a Sunday. It's quite possible, they were out of the office and spending time with their family. Defendants' current position regarding the nature of their agreement is of little moment because defendants never opposed the extension Miss Lively requested on April the 7th. Explaining that the response was in opposition to Miss Lively's request for an order compelling compliant witness list without taking any position on Miss Lively's designation extension request. That non-opposition was consistent with defendant's subsequent agreement to the same relief, but regardless, given the revelation that Miss Lively's original extension request is apparently not moot, the court should now grant it as unopposed. I don't agree with that. I'll tell you why I don't agree with that, just before I go on. If I was when I was working in law firms, if I had agreed to something in writing, if I had agreed to something during a telephone call or a meeting, right, a verbal exchange, I would, I always then follow up and say, further to our conversation earlier, further to our phone call, just to confirm this was agreed. And then I will list all the things, you will do this by this date, you will do that by that date, your client will pay this, you will provide us with that. And very clearly list all the things that were agreed to be done, all the actions that were agreed to be taken. Who's responsible for that? When? What's the deadline? What's the consequences? Well, I might go to, seek relief from a court, or, we will withdraw from this other part of the agreement if you do not fulfill this part. It could be, but you know what I mean? Like, make a contemporaneous note, right? Of if you have formulated an agreement in some kind of verbal form, whether it be during a meeting or through a telephone video call, you then, it's quite, I would, it's a sensible thing. I definitely recommend doing it if you don't already, but then to just quickly follow up and say, just referring to this conversation, you've agreed to this and I've agreed to do that. If someone doesn't agree, if something's wrong on that and someone doesn't come back and say, respond by email and say, no, sorry, that date is wrong or that amount is wrong, this is actually what we agreed to. If they don't oppose your contemporaneous notes, like that's their opportunity to correct, right? Then yeah, I agree that they have basically, agreed to whatever you put down. Because the whole purpose of you contemporaneously, putting things in writing and sending it to them is to give them the opportunity to, confirm, yeah, that's okay, we agree to all that, or, refute. It's like, no, yes, I agree to this, this, and this, but that bit is wrong, and then correct it. And if they miss that opportunity, and a year later when you go to enforce or whatever, some time goes by, you then go to rely on that contemporaneous note, and it appears, in court, and you're like, well, hold on a minute, at the time, this is what we agreed. And they're saying, well, no, and verbally we agreed to this. Yeah, but I followed it up in writing. Here it is. This is actually what we agreed to. You've got that bit wrong. The written note actually holds a lot of sway because it's written in the moment. And that literally there is an opportunity for them to respond and say, no, that's wrong. And if they don't, then they've missed the opportunity. But if you're having just a back and forth and someone says, by the way, can you give us a bit of extra time, right? And then that other party then, this wayfarer in this case, that other party then says nothing. I don't see that as, oh, well, you didn't say no, so I'm going to take that as an agreement. I hope I'm making some sense here. I just think it's very different scenarios. Like, you're just casually say you're communicating through email anyway, and you're saying, we want to request an extension of time. Well, they might have agreed to it previously, but if something's happened now to change that, i.e., Wayfarer, provide the information you want, and then you talk about the extension and they say nothing, I don't see that as an agreement. It's unopposed, yeah, but I wouldn't say, well, they've agreed. They've clearly waived their right to say no. That's in that scenario, I don't see that as being the way it should work. That's just, I don't know if that's just a British thing though. To the extent that defendants mount an opposition now in hopes of excluding Mr. Sarrett's and Miss Abel's testimony from the trial, the court should reject that opposition. Defendants have not articulated any prejudice to granting this extension, whereas the prejudice to Miss Lively would be extreme. Moreover, the need for this extension arises from defendants' own delay in identifying which witnesses would testify in person consistent with the court's individual rules. Hold on a minute. She hasn't identified her own witnesses, apparently, and she may have now, but at the time Wayfarer wrote that letter to the court, she hadn't. Miss Lively's April 7th, 2026 letter motion to compel is made two independent requests. First, that the court compel an exchange of compliant witness list by April 8th, and second, that the court grant an extension for Miss Lively to provide deposition designations for any non-appearing parties by no later than 1 week from the date by which this information is disclosed by defendants, to provide time for a complete exchange of deposition designations, counter designations, and objections as to these individuals if necessary. On April 8th, at approximately 9:03 p.m., defendants transmitted a revised witness list and stated, "You will note that the asterisks appear by Baldoni, Heath, Nathan, and Abel's names. We agree that all parties will have until 1 week from today to submit designations, objections, and counters to the court with respect to these 4 witnesses." So that's going to be in Exhibit A. We'll have a look at that. I haven't looked yet. On April 9th, at approximately 5:59 p.m., defendants filed a letter reporting that defendants would soon comply with the request to provide a compliant witness list, but in that letter, defendants said nothing and therefore did not oppose the extension request with respect to submitting deposition designations. Instead, defendants reported that their witness list would indicate that Stephen Sarrett and Jennifer Abel will not appear in person but by deposition, and concluded, based on the foregoing, defendants respectfully request that the court deny plaintiff's request to compel disclosure of which witnesses will appear at trial and which will testify by deposition. Defendants' request for additional time to exchange witness lists is moot. Shortly after, at 6:43 p.m., the court denied Miss Lively's letter motion as moot. After the court's order, at approximately 7:24 p.m., defendants emailed acknowledging that plaintiff's exhibit list reflects that she intends to designate testimony from Mr. Sarrett and Miss Abel's deposition, and asking, when can we expect to receive those deposition designations? That email gave no indication that defendants understood the court's order as having any effect on the parties' April 8th agreement regarding the deadlines for exchange and submission of designations. They requested that the court deny the request for extension of time as moot, and the court did that. Surely that's self-explanatory. I don't understand what Lively's looking for here. Well, the email didn't say that they understood what the court's order meant. What? Defendants provided designations for Ms. Abel shortly after midnight on April 10th. The same day, designations were due to be filed without any indication that they were expecting counter designations later that same day. providing yet more evidence that defendants were availing themselves of the parties' agreed extension. On April 10th, the parties filed the joint pretrial order and related documents. Neither party included designations for Miss Abel or Mr. Saueritz and their joint submission. That same day, Miss Lively filed a letter informing the court that the parties had agreed to an extension of the deadline to submit designations with respect to any of Justin Baldoni, Jamie Heath, Steve Saueritz, Melissa Nathan, and Jennifer Abel, who defendants have confirmed will testify at trial by deposition rather than live testimony. Yeah, but she was wrong on that, because the letter to the court that she's responding to clearly made note that Justin Baldoni, Jamie Heath, and Melissa Nathan would be testifying live at trial. Because when I read Lively's letter, her quote-unquote joint pretrial letter, I got really confused. Like, you can hear it in the video. I'm like, what? I thought that, and I was like, I thought that they were testifying live. The letter said, and I was confused as to why she was saying that, and Wayfarer did call her out on it. Counsel for defendants emailed at approximately 12:02 a.m. on April 11th, stating, "We do not agree to any such extension of time. The court ruled your motion for an extension was moot." Defendants' counsel demanded that Ms. Lively immediately withdraw your letter request, or we will seek sanctions. When Ms. Lively's counsel expressed confusion and pointed to defendants' counsel email of April 8th, defendants' counsel stated that email was superseded by Ms. Garofalo's letter to the court informing Judge Lyman which witnesses would and would not appear in person at trial. The court found the issue you raised, requesting an extension of time to respond to designations, was moot. With this background, defendant's April 11th letter reflects, at best, a mutual misunderstanding that defendants helped create, and at worst, a brazen attempt to renege on their prior agreement to extend the deposition designation schedule for the limited set of party witnesses who had been expected to appear live, but have now elected not to do so. That's not true, though. Because Ellen confirmed, she's still suggesting that Justin Baldoni, Jamie Heath, and Melissa Nathan are not going to appear live, that they were, but now they're not. That's not what Ellen's letter to the judge said. Either of the letters, actually. Unless I see something from Wayfarer's legal team saying, yeah, these were going to appear live, now they're not. Lively's talking shit. That agreement was not conditioned at all, much less conditioned on the outcome of defendants' internal deliberations as to which of the dismissed defendants would appear in person or on Miss Lively's letter motion to compel being granted. Thus, it was not superseded by defendants' sending of a revised witness list or by the court denying plaintiff's letter motion as moot. In fact, defendants' non-opposition to her request for an extension of deposition designation deadlines, combined with the court's denial of her entire letter motion as moot, further confirmed Miss Lively's understanding that defendants had assented to all the relief she had sought in that letter motion. What is Lively saying here? People should honour their agreements and do just what they say they're going to do? Is this like, when she said, well, if Justin Baldoni's cut performs better than mine, I will walk away and shut up and, drop the idea of having my own cut. But then she didn't. And then she got all her friends to, interject, even though her cut did, worse. Is that what we're talking about here? What I'm hearing is she will not live by her own rules. She's expects everyone to do exactly what they say they're going to do, but she's quite content to go through life doing whatever the hell she wants to do, regardless of how it affects people. That's what I'm hearing. Defendants' about face from their agreement serves no purpose other than to force needless litigation. Their explanation that their agreement was superseded makes no sense. The term moot means intervening events have made it impossible for the court to grant the requested relief. If Miss Lively's letter motion was moot, it was because defendants' agreements to Miss Lively's request made it so. It is absurd to suggest that the court's subsequent denial of Miss Lively's motion as moot cancelled out that very agreement. Whatever might be said of their position as to Mr. Sarowitz, it is frivolous for defendants to now claim that their agreement did not extend to Miss Abel. Defendants' apparent goal appears to be to keep the jury from hearing Miss Abel's and Mr. Sarowitz's testimony entirely. The court should hold defendants to their agreement, or to the extent this court finds that the parties did not have an agreement, the court should simply grant the extension that Miss Lively originally requested on April 7th, which was unopposed. Defendants did not on April 9th and cannot now articulate how the requested extension of designated deadlines could possibly prejudice defendants. By contrast, denying the extension would significantly prejudice Miss Lively, who defendants deigned to inform on April 8th, 2 days before the deadline to file the joint pretrial order, and after Miss Lively's repeated request that two-party witnesses within defendants' control would not be testifying live at trial. The loss of those witnesses' relevant testimony would significantly prejudice the merits of Miss Lively's case. That's what's going to prejudice the merits of your case. It's just not the fact that you just don't have one. Defendants should not be permitted to seize an artificial advantage from confusion and delay for which they bear the lion's share of blame. For the foregoing reasons, Miss Lively respectfully requests that the deadline to submit deposition designations to the court for Mr. Sarowitz and Ms. Abel to be extended by April 17th, 2026, with the parties to serve affirmative designations for these two witnesses by April 13th, any counter designations by April 15th, and any counter designations by April 16th, to allow for an orderly process to submit completed designations and objections to the court. Okay. Wow. She's adorable, isn't she? Let's have a look at these emails. Just work out which way to go. So that is April 8th. Okay, so we always start at the bottom. I've learnt with these because that's the earliest email. Okay, so this is from Stephanie Rosa, from Manat, so Lively's lawyer. Kim. That's Kim Zeldin, who is Wayfarer's lawyer. Following up on our call, we will agree to a mutual exchange of the parties' updated witness lists for witness. Start that again. Following up on our call, we will agree to a mutual exchange of the parties' updated witness list tomorrow, with the updated list clearly identifying in good faith who each party presently intends to call in person or by deposition, including for Justin Baldoni, Jamie Heath, Melissa Nathan, Jennifer Abel, and Steve Sarowitz. We had every intention of doing this on Sunday, as set forth in our proposed schedule. Defendants, however, never responded or agreed to our proposed schedule and have instead indicated that they will not identify which of their own clients they intend to call in person or by deposition. Of course, the distinction in our positions is that Miss Lively does not control whether the third-party witnesses outside the court subpoena power decide whether to testify in person. By contrast, each of Baldoni, Heath, Nathan, Abel, and Sarowitz are in complete control of whether they decide to testify in person. The only thing standing in the way of disclosing their intent is their willingness to do so. Please confirm your agreement to the above mutual exchange. Miss Lively reserves all rights. Stephanie, what time do you want to this is from Kim. What time today do you want to exchange the witness list, please? We plan to get you the joint pretrial order, jury instructions, and verdict form today. Stephanie, So this is from Stephanie. Thanks, Kim. We propose a mutual exchange at 6 Pacific time today. So that we may update the court regarding the parties' agreement, please confirm that 1. Defendant's revised list will indicate whether witnesses, including Baldoni, Heath, Soweritz, Nathan, and Abel, will appear live or by deposition. And 2. You agree to the extent that defendant's list indicates that any of Baldoni, Heath, Soweritz, Nathan, or Abel will appear by deposition. The parties will have until 1 week from today to submit designations, objections, and counters to the court. Okay. So that's where she's saying, can you confirm? So she's not saying, that she's asking for something. Now, I don't know whether they've had a conversation, like a meet and confer, and they've said, they've agreed to something in principle, and then this is her technically following up in writing. But there is not, normally when they do that, they refer to the meet and confer. And then the response from Kim. Stephanie, attached, please find defendant's witness list. You will note that asterisks appear by Baldoni, Heath, Nathan, and Abel's names. We agree that all parties will have until 1 week from today to submit designations, objections, and counters to the court with respect to these 4 witnesses. Okay. So this is the 8th. So 1 week would have been the 15th, which is what Lively did put in her request. That was the deadline she was going for in her request. So let's look at other emails first. But so far, yes, okay. They asked and they agreed to it. So this is from Alice Buttrick from Shapiro's law firm. Counsel, please find the attached. What day is this? Yes, this is April the 8th. Please find the Wayfarer Party's amended exhibit list. We have added the following exhibits. So there's some exhibits there. Oh, Sigrid Macaulay's 2 different conflicting statements. Nice pull clips. Right, there we go then. So this is this literally put together all of Lively's motions in limine. The non-base numbers are available at the following Dropbox link. I will send a password. Right, it's okay. Wayfarer parties continue to reserve all rights to modify this exhibit list and to use any exhibits on Lively's exhibit list. Now the email from Alice. Further, my prior email. Please find below the password to access the Dropbox link provided, and the exhibit list is now attached. Okay. And then Kim. Counsel, please find a clean and a red line of the joint pretrial order. Plaintiff's new section on pending motions has been deleted. That is not one of the topics Judge Lyman requests or requires in the joint pretrial order. Judge Lyman is aware these motions are pending and there is no reason to include them. Please note we have taken out Lina Friedman and Brian Friedman's names in the list of people and institutions the jury may hear about section. Any possible reason to include them was eliminated by the summary judgment ruling. And then we got Kristen Bender. This is all still April 8th. Please see attached for Miss Lively's witness list. Okay, that was exciting. Okay, Kim. Counsel, as indicated in Ellen Garoppolo's letter to the court today, we have amended defendant's witness list. We note that plaintiff's exhibit list reflects that she intends to designate testimony from Mr. Soweritz and Miss Abel's deposition. Please let me know when we can expect to receive those deposition designations so that we may provide counters. We will provide you with designations for Miss Abel's deposition today. Okay. So they were going to so they're asking now, please let us know when we can expect to receive deposition designations so that we may provide counters, and informing that Wayfarer's side are intending to provide Lively with designation for Abel's deposition today. And that was on the 9th of April, which was Thursday. So then let's now look at this other email. 14 pages. Oh, joy. Right. For some reason, I feel like this could be interesting now. Okay, so this is April the 8th. Council, please find charts showing the Wayfarer Party's objections to Lively's counter designations and counter designations. Highlighted versions of the transcript showing the limited counter designations will follow this evening or tomorrow morning. As before, the Wayfarer Parties reserve all rights to revisit these materials and to supplement or revise their objections and counter designations. We expect to receive Lively's objections and counter designations this evening as well. So that was on April 8th. I'll have to look at the times. This is 6:24. Let me just, while I've got it in my head. 6:24. 6:24 p.m. So this email here agreeing to the 1 week was 9:03. So that came after that email. Oh. Okay. Yeah. Then we have an email from Emir, who is Wayfarer's counsel, Freedman's firm. Counsel, please find defendant's red lines to plaintiff's version of the jury instructions along with a clean version. We're obviously not getting the attachments they're talking about here. Then we have another email from Alice on April 9th. Good afternoon. We made one further change to the jury instructions attached at page 27 for discussion today. April 9th, Stephanie Rosa, Lively's counsel. Including below a proposed agenda for the call. So they're planning the call, right? 1, exhibit list. 2, witness list. 3, voir dire. 4, joint pretrial order revisions. 5, motions in limine. 6, jury instructions. And 7, Doberts. And just, I know I've said this a couple of times, but everyone knows the rest. But Doberts are they're basically oppositions to the and objections to the experts. And we saw some of that, where we saw Lively has filed letters seeking to exclude testimony and deposition from various experts from Wayfarer's side. Wayfarer have done the same. That is what is a Dobert motion, basically. So this is from Stephanie. Counsel attaches an updated version of the joint pretrial order with Miss Lively's further revisions in clean and red line. As always, Miss Lively reserves all rights, but denies anyone else's. From Kim, Stephanie attaches an updated version of the PTO with defendants' further revisions in clean and red line. This is the 10th of April. This is from Kristen Bender, who is Lively's counsel. Counsel, plaintiff's proposed final joint pretrial order is attached, clean and red line, which now incorporates the parties' witness list. For ease of your review as to additions, removals, plaintiff's witness list now includes Sophie Travaglia, who is Lively's personal assistant, I believe, but removes Brian Perrott, who I cannot remember who that is. Obviously not important because they're removing him. Also attached is proposed Exhibit A to the joint pretrial order, which is a compendium of all the deposition designations. Note that Exhibit A includes objections to defendants' counter designations to plaintiff's designations of Wallace's deposition, which were inadvertently omitted from a prior transmittal. Please let us know if you are signed off on the joint pretrial order and Exhibit A. Plaintiff intends to file separate docket entries for the parties' voir dire and questionnaire and proposed jury instructions, proposed finals of which will be forthcoming. As noted earlier, each party should file its own proposed verdict sheet, and we will proceed on this basis. So I do intend to do the witnesses list next, and then the jury instructions and voir dire after that. I will try to get to the main crux of the motions, and I'll do attachments as a separate thing later, at the end of it all. I'm trying to work out how to get through all of this before all the oppositions come in then on Friday. And there's just such a lot to go through. But I mean, this stuff, the pretrial stuff, is the stuff I love. I got so excited. I went straight for the motions in limine because I want to know what people what each side doesn't want doesn't want the jury to hear about. And it tells you a lot, really. And when I saw Lively's, I was like, oh, she really doesn't want. She doesn't. I don't think she's got faith in her own case. I don't. But I will probably do an updated video where I go back and sort of summarize some of this stuff and just like, actually, this is how I think things are going, because this is where we learn how the trial is going to proceed, what it's likely to look like, because everything that's filed on the docket it's not entered in as evidence. So a lot of what we've seen actually might not make it in front of the jury, and it will not form part of the actual trial. And the trial is the important bit. What's going on the docket is just, them teasing out this kind of end game that we're in now. So a bunch of stuff that's hit the docket already, we've all sat and enjoyed and gone through, but there's probably a lot of it that's not even going to make it to the trial itself. But this is where we kind of see what is going to go in front of the jury, more than likely, what they intend to put in front of the jury. What happens on the day will be a whole other thing, but you get a flavor. You get to kind of look into some of the strategy, because before we've not looked at that, but now we're seeing more of it. Really exciting. Okay, continuing on. So we're still on April 10th. This is from Kim. Kristen, you used an outdated witness list. I sent you an email yesterday at 4:24 p.m., which your side already acknowledged you read. You have not read this document in its entirety, but if you could fix this and resend, then we will do so. And again, like, that just makes me think, right? Just on the back of that, because obviously Lively was in her joint, quote unquote, joint request, which is now like at the center of this little fight. I was sitting there, I was like really confused. Hold on a minute, do they has something changed? When she was saying that all the parties were now going to be deposition designations, even though we'd had a letter on the docket only earlier that day from Wayfarer saying these are going to appear live and these are going to appear by deposition. And I was sitting there and I was absolutely baffled. I was like, hold on a minute, did she not read? What's going on? Has something changed? And then when Ellen then kind of filed and said, hold on a minute, there's all this information and it's wrong. And now we're sort of seeing, like, Lively's team are just not paying attention, because they've done it here again. And Wayfarer are like, what are you doing? That's the witness list you're relying on is out of date. Something's changed. We've updated you. We've had acknowledgement that you've read it, and yet you're still not referring to it. What is going on? So, and I said I would talk about this actually. So either there was, with the letters that were filed on the docket about who, from Lively's team, suggesting that all of the Wayfarer parties were going to be deposition designations. There is a bit of me that is questioning whether because I believe that obviously things changed, that the court ruled, the request as, he denied it as moot. And then suddenly we're getting a letter then saying, well, we've all agreed to this, right? With information that is deliberately wrong and or out of date. And I do, because of the way it got slid in, right? And I'm quite confident, I don't know this, but I'm confident that that was deliberate. Why? Partly because she never sent a copy to Wayfarer. And if they don't receive it, if they don't get notice, then they can't respond to it. But also the information was wrong. And I believe possibly because it was out of date. And I think that's deliberate. I think that was part of the ploy to plead ignorance. Oh, what are you talking about? But we had no idea, that kind of thing. I think she knew fine well. I think they knew, Lively's team knew fine well who was doing live deposition, who was doing live testimony and who was doing deposition testimony. But by pretending to be stupid, but by being stupid, coming across as stupid, with information that wasn't correct, they can now sort of, as they have done, gone argued and gone, what's going on? We are blindsided. We are, rattled by this. I think that some of that is what's going on here, and I think some of it is a bit of, it's deliberate. And I don't like to say that, but I mean, I was a bit astounded that by Ellen's letter to sort of say that, hold on a minute, Lively's team are lying. We knew nothing of this. We did not consent to this. And the first thing that crossed my mind is, this is literally coming in on a day where they are asking in their motions in limine for Van Zandt to be kept out because they don't want to be, they don't want the jury to see that they have these underhand tactics and unethical legal maneuvers. And the jury won't see this. They won't see this argument here over these letters and the request for the extension of time. But it is always fascinating for me to be like, yeah, if the jury sees Van Zandt and is horrified by it, whether it's legal or not is a whole other question. It's certainly unethical, and there's been consensus amongst all of us legal commentators on that. Absolutely, there are some times where you play hardball to get what you want, but you always work within the rules. And professional courtesy is incredibly important. It's such a big thing in the legal sector, and there was none with Van Zandt, and it feels like that there's more of that again here. And the same with our motions to quash this, the content creators subpoena. It felt like the courtesy, the respect was not there. And then when we did respond, for those of us who actually did respond via the docket with a motion to quash, there was no professional courtesy. In fact, she did exactly the same thing as Wayfarer just done to her. She pulled the rug. She, instead of responding to our motions to quash, she just said, "Oh, deny them as moot. We've withdrawn them." So, but she, the sleight of hand in there though, by suggesting that we had met and conferred with her, and she didn't now need the subpoenas against us because we'd already given her the information that she wanted, and they didn't need to get any more further information from us. So I have no sympathy at the moment for Lively for stuff like that, because she does it. In her case, it's worse. But we continue. Sorry, I do have my little side kind of because I have thoughts as I'm going through things. So, and I say it, and then if the situation changes, I'll update my thought. But I do like to assess some of this as well from, well, this is what I would do if I was still, in law. or I have never done that. I have these moments. Okay, so Kristen Bender. So she's responding to Kim. Please see attached for the updated joint pretrial order as requested. There is also please also review the voir dire in clean red line and let us know of any final changes or whether you are signed off. You'll see there is a question added in the voir dire that is simply an adoption of defendant's suggestion to split a question in two. From Kim. Counsel, attached, please find the joint pretrial order. I fixed Windows orphans and included and added from Holtz back in as a witness. Can we see the completed document with exhibits before you file, please? Ellen Garofalo will be signing off on defendant's behalf once we approve it. Kristen Bender. Please see attached for the final proposed joint pretrial order and exhibits B and C. Exhibit A was conveyed earlier this afternoon and remains the same. Please let us know if there are any issues. We are finalising as you review and aim to begin this filing at 11:40 Eastern. If we can please receive prompt approval or final edits, thanks. Are we getting to the point where this is all relevant to the motion? Kim, that gives us less than 10 minutes. Sorry, we'll get back to you when we can. Kim, please also review the attached unchanged but for the cover and signatures. Amir, okay, to go. Kristen, received on this and Kim's approval on the joint pretrial order. Thanks. Here we go. Finally, is this all of that? And it's just Kim, Ezra. We did not agree to any such extension of time. The court ruled your motion for an extension was moot. Also, your letter erroneously states that defendants confirmed that Justin Baldoni, Jamie Heath, Steve Sauritz, Melissa Nathan, and Jennifer Abel would testify at trial by deposition rather than live testimony. Immediately withdraw your letter request or we will seek sanctions. Stephanie. Kim, you explicitly agreed to this extension in writing on April 8th. See attached. At no time did you or anyone on your team withdraw the extension. Anything you file with the court will be immediately followed by a letter from us attached in your email and written agreement. We are genuinely confused by your position and do not understand what it is you are trying to say. If you're saying you can't have an extension. I'll finish this. It was our understanding that this extension would apply to the two parties that would be testifying by deposition only, which you only informed us of yesterday afternoon despite repeated requests and after a lengthy meet and confer call. We have been endeavouring to finalise the designations to get them to you in time to provide objections and counter designations so that we could jointly file on Wednesday. If you have some other understanding or expectation, please let me know. Now, there's one part I don't agree with here. At no time did you or anyone on your team withdraw the extension. I would say that the letter to the court opposing the extension of time effectively withdrew it. The letter before the judge ruled to deny. Not Ellen's letter yesterday. The original opposition to Lively's request for an extension of time, which at that time it was just for her. The letter she originally filed was just for her to have an extension of time. I'll have to look at all the letters, I think. Okay, so let's go and have a look at the letter. One thing slipped my mind was actually the request for the additional time by Lively wasn't like a motion for an extension of time. It was a motion to compel. And this where maybe the confusion has actually occurred. So this is the motion to compel from Lively, right? And at the bottom, she's gone through the whole guff of, they haven't done this and they haven't done that, and we need the court to tell them to do this, blah 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 blah. Accordingly, Ms. Lively requests that the court compel disclosure of this information in compliance with this court's Rule 5A9 and grant a limited extension of 1 week from the date by which this information is disclosed by defendants to provide time for a complete exchange of designations and objections. And if you look at the date, if we go to the top, right, and look at the date, this is April the 7th. This, I'm not entirely sure if I will come back to this, but I just want to go back to Exhibit A for a minute. Is it Exhibit A? Maybe it's is it Exhibit B? It's like trying to work out which cup has the ball in it. Okay, so it's not that either. Which one is it? I think it is this one. Just right, yeah. Sorry. Right, so we agree that all parties will have until 1 week from today to submit designations, objections, and counters with regard to these 4 witnesses. This has come in on April the 8th. Lively's initial request was, on April the 7th. It was a motion to compel, and it was, can you give me a week, right? But then on April the 8th, right, yeah. So April the 7th was the request, and this is the email, the April the 8th, you will have 1 week, right? And then we go to this, which was Ellen's opposition. Nevertheless, at an April 4th meeting conferred, plaintiff insisted that defendants immediately disclose whether the dismissed defendants would provide live testimony. Plaintiff again ignored her own witness list, which suffered the same shortcomings she complains of here. And then at the bottom, based on the foregoing, defendants respectfully request that the court deny plaintiff's request to compel disclosure of which witnesses will appear at trial and which will testify by deposition. Defendants' request for additional time to exchange witness lists is moot. Now, they were trying to sort this out in the background, but Lively filed a motion to compel. So, to me, it looks like Wayfarer gone, well, fuck you. It looks like there has been maybe some crossover in the email, because Ellen Garofalo was the one responding on the docket. Not Stephanie, it was Kim Zeldin who said, okay, we can agree to a 1 week from today. But then Lively then filed, because there was a motion to compel, which was denied. So then Lively then files a joint, we've agreed to an extension motion and does not send notice of this to Wayfarer, and kind of does a little bit of wordplay on it, shall we say, a sleight of hand with words, which I have shown so many examples of her doing that, right? I'm no longer surprised by it. And I think that's what has pissed Wayfair off. It's like, hold on a minute, lady. You filed this request as a motion to compel. It was denied. You got the information you want. By the way, we still haven't had the information, the same information from you. And then, and the judge was like, yeah, you're not getting the extra time. And then Lively basically unwrapped it and then repackaged it. Like, it's like buying someone a birthday present and then just taking off the wrapping that says happy birthday and putting Merry Christmas on it and refiled it as a quote unquote joint request for an extension, relying on this email. I hope that I'm doing my best to explain it. It's not as, but I'm hoping that hope that makes some sense. That's what's happened here. Of course, we've had to go through all of this to unpick it all. Okay, so we are back to this now. Okay, so now we've all got that. Now we know what's happened, yeah? Okay, Ezra, that email was superseded by Miss Garofalo's letter to the court informing Judge Lyman which witnesses would and would not appear in person at trial. The court found the issue you raised, requesting an extension of time to respond to designations, was moot. Regardless, you still made misrepresentations to the court when you stated that Mr. Baldoni, Mr. Heath, and Ms. Nathan would not appear in person at trial and would appear by designation. A simple check of our exhibit list and Miss Garofalo's letter to the court and the court's order shows otherwise. We did not and do not agree to any extension of time, and were completely blindsided by this letter to the court. Kim, it appears that you are misinterpreting the language of our letter. We did not represent that Mr. Baldoni, Mr. Heath, and Miss Nathan would not appear at trial. You did. They did, right? Because even I go and listen to my video where I'm actually reading that part, and you can hear me go, huh? We meant only to describe the nature of the parties' agreement on April 8th before we were notified that the individuals would in fact attend despite multiple requests. There would be no way for us to understand that you were interpreting the judge's order as a withdrawal of your agreement to extend the designation's deadline. That was never communicated to us, and we further note that your team sent an email today asking when we would send the designations, which further led us to believe that we were all operating on the same timeline. If it is still your position that you refuse to engage with us on designations for Sarah and Abel, we would happily submit a letter to the court sharing this correspondence and requesting an order for an extension through Wednesday. Alternatively, you could honour your initial agreement and save us all, including the court, a lot of trouble. Let us know. I am absolutely sick of this. I just think that's ridiculous, okay? She filed the request for an extension of time as a motion to compel. It was denied, including the extension of time, right? Wayfarer clearly opposed it and the judge denied it and agreed with Wayfarer. She then tried to then say, hey, I tell you what, Judge, we've all agreed based on that one email, right? And she's just gone to fucking town on it. Like she did with the Madison Square Gardens, right? It's like, you know, and she sits there and she's like, oh, well, you didn't give us any clue that you were withdrawing from this agreement we had over email. It's like, really? The opposition didn't give you that clue? And stuff like this really annoys me because it is clear that they are not agreeing to that extension of time. I don't know how much notice Wayfarer even had that Library was going to file a motion to compel. Didn't seem to come up in anywhere in the email correspondence, the back and forth. Oh, by the way, we filed a motion to compel because you're not giving us this. It actually seemed quite pleasant, the email threads, until that last one with those last few entries where they're actually addressing the the whole subsequent letter and the response. And I do wish that Wayfarer would actually file for sanctions because it was misleading. And I do think it was deliberate as well. The reason I think it was deliberate was because the information was wrong, and it was information they knew was wrong as well. The evidence is here in amongst these email threads that Lively's team knew who was appearing live and who wasn't. In fact, they made a mistake already in the email thread and had that pointed out to them. So they'd already had it clearly pointed out. That's why I'm like, no, you knew that all of these people were not appearing by deposition, and it makes a difference. It does make a difference. But also the fact that they didn't give notice. They didn't copy in Wayfarer. Like when you send the letter to the court, you also send copies to the counsel for the parties as well. I did it. When I filed my motion to quash, I sent, I copied in the email all the attorneys. Because that's, you do that. That's what, and they will have done that time and time again. All these filings that we got, they would have done that. So to me, that's not an accident. And maybe I'm being a bit cynical, but Lively's team, it's hard not to feel like that sometimes. But yeah, that's what's happened. So initially it was a motion to compel. It was denied. So now it's like, oh, judge, look, we both agreed to this. Well, if what Lively's counsel genuinely believe Wayfarer's counsel still agreed to a week's extension after the court's order, then why not just notify them that they're sending that? Makes no sense. All right. I'm going to line up the what am I doing next? Oh yeah, the witness list, which should be fun. See you later, guys.